that it is under the National Registration Act that citizens of Guyana, based upon satisfaction of the qualifications, are registered and they become part of the national list of registrants. And when an election becomes imminent, then a series of statutory triggers are activated. And from that national list of registrants is extracted a preliminary list of electors. And from that preliminary list of electors that another process is undergone, which produces the OLE, or the final list of electors. And that is why there is a connection between the National Registration Act and the electoral process. Now, I spoke at length in my opening remarks about us in Guyana making legislative changes in relation to the impending elections. So, in 2005, as we were approaching the 2006 elections, and there was a local government elections also that was evident at that time, we decided as a collective of the political directorate across political parties that we will move the registration process from a one-off process that it was to a system of cyclical continuous registration. In fact, I have here a document that was signed by the political parties as an agreement going forward, and the relevant statutory changes were made. Then, even after the elections, I believe in 2007 or 2008, there was another agreement by the political directorate, all the political parties. And they said, look, when we first introduced the continuous registration system, we decided to use the electoral roll for the year 2001 or the 2001 elections as the base, and then start the continuous registration process from there. And that we had to amend the legislation to introduce the cycle. And then, for whatever reason, in 2007, 2008, the political parties agreed again that they will stop the cycle and they will do a house-to-house registration to update the database. And that, once that was done, then that will be, that updated database will then continue to produce a national list of electors and preliminary list of electors. I have the thing in my hand here, the government of Guyana, the People's Progressive Party, the People's National Congress Reform, the Alliance for Change, the Guyana Action Party, Rise, Organize and Rebuild, the Upper Roll, the United Force, and the Guyana Elections Commission agreed that prior to the holding of the forthcoming local government election, a national 2007 house-to-house registration of all eligible registrants 14 years and over will be undertaken by the GCOM, and this will constitute the country's new national register of registrants. This agreement was then reflected in the law because you have to stop the cycle. That's the only way. You have to amend the law because the cycle is part of the law. You have to stop the cycle to allow this to happen. And it was agreed in that very agreement that all of the above mentioned parties agreed that the PLE for the scheduled 2011 general elections will be similarly extracted from the NRR created from the 2007 House-to-House registration exercise, and any revision occasioned by the continuous registration by the continuous registration process. After its revision, a final list will be created for the next general election scheduled for 2011. And it was agreed that there will continue. And that is what has happened. All the parties signed to this. And that is the list that has gone on with its continuous registration cycle in accordance with the law. And that is the list, that is the national list of registrants that is today available, and that is what was used for the 2011 elections without any objections, 2015 elections without any objections, 2016 elections, local government elections without objections, 2018 local government elections without objections, and 2020 elections without objections. I don't know how suddenly this very list that has put people in government have become this big bad wolf. This very list. And as I said, the list, you can't take people off the list, and I've given you the rationale and the explanation already, lawfully. Those who had a problem with the Chief Justice's ruling, if they felt that the Chief Justice was wrong, could have appealed. GCOM was a party. GCOM brought in a lawyer from Trinidad and Tobago, a senior counsel at the time. I can't remember his name. Stanley Marcus. APNU, AFC was represented. The Attorney General was the respondent, Basil Williams. No one appealed. They accepted the decision of the Honorable Chief Justice. That remains an undisputed expression of the laws of this country, or an undisputed interpretation of the law. So I say that to give you a backdrop to understand the continuous cycle of registration. One of the main purpose, or one of the main driving factors in the amendments which are proposed to this piece of legislation is to further ensconce that continuous registration system, and significantly to fix by law when the cycle is to stop for the purpose of claims and objection, and when the cycle is to start back running to register people all year round. So you have a system quite independent of elections that is running all year round to register citizens of this country as they become qualified, based upon a qualifying date that is now fixed by the law. So we don't have to wait until G come to fix the date anymore. We are putting it in the law. And the two qualifying dates are every year, it reads this: every year, registration of persons who, on the 30th of June, are qualified under subsection 1 to be registered, and on the 31st of December. So these are the two dates, the qualifying dates. So if you attain 14 years and over by the 30th of June, from January to the 30th of June, you can go to any registration office and get registered. The system, the cycle will then be paused for claims and for all the transactions to be published, for there to be a claims and objections, and that lasts 1 month. Once that process is completed, the data there, sanitized, goes and become part of the national list of registrants. And then the cycle resumes. from from August straight to December again, December 31st being the qualifying date. So once you become 14 years and over, on December 31st, you begin to register from August all the way to December. January, we pause again. And it's as simple as that. And most importantly, in Guyana, unfortunately, we confuse, and that's what this thing seeks to do. We always confuse registration with elections. They are two different processes. Of course, from the registration process will come the list of electors. But politics blur everything in this country. So registration of citizens, when they become qualified, is of important civic responsibility and important national undertaking. Yes, I'm getting the ID card. And yes, I know. And that process I want to disengage in people's minds. And we have in the law now that when you are registered, quite apart from elections, you get your ID card as soon as it's practicable. All year long. It got nothing to do with elections. You don't have to wait until elections because everything has become so connected or confused. I'm not sure which terminology to employ. So now you have a civic registration exercise that is ongoing all year round that has nothing to do with elections. But what it does, at every 6 months period, it puts GCOM, or it puts the National Registration Center, for which GCOM has responsibility, in a state of readiness every 6 months to produce a list of electors. So we can't have that situation where you had a commissioner of GCOM, a chairman of GCOM, dilating for 1 year, claiming that GCOM is not in a state of readiness. GCOM will never be in that position once this law is implemented. Every 6 months, GCOM can be ready with a list. Every 6 months. And the law requires the president, whoever he is mandated to give at least 3 months' notice under the Constitution to fix an election date by a proclamation. Because he has to dissolve Parliament and he has to give a minimum of 3 months' notice. That 3 months is way sufficient for GCOM now to stop that cycle, move from the National Register those people who are qualified on that database and shift them over to become now part of the PLE, or the Preliminary List of Electors, and for the electoral process to kick in. So that's one of the main thrust of these collection of amendments. Clarifies those positions as far as possible. So that's one. Two, it also examines, because we have introduced the continuous registration system, unfortunately in a piecemeal manner, with 3 pages of amendments and 2 pages of amendments when it suited us. The thing was simply not neat. And elements of the old system was there. What this legislation does is to remove those obstacles, those provisions that sometimes put you in doubt as to whether we have a continuous system of registration or not. So we have removed those contaminants. So you now have a legislation that reads clearly that Guyana has embraced fully and absolutely a continuous system of registration. The third component of the recommendations or the proposed amendments address the critical question of residency. Now, there are provisions in the current Registration Act that speaks to residency being a requirement for registration, or it reads that way. Now, in Guyana, our Constitution is supreme. The Constitution, as I said, has two requirements only for registration. You must be 18 years and you must be a Guyanese. Any legislation that is in conflict with, that is in tension with, that is inconsistent with, that slightly or otherwise is on a collision course with that core constitutional requirement, that legislation, insofar as that inconsistency exists, is unconstitutional. So wherever it read or it lended to the conclusion or to an interpretation that you have to be resident in a particular area for you to be registered, we have clarified that. You don't have to be resident in any area. You must have an address. You must have an address in an area in which you think you are likely to vote. And you will be registered in that area. Insofar as the law required you to have an address, when residency is not a requirement, that law was offensive to the Constitution. That is why when GCOM, and we have put in the law, again, clarified that GCOM is free to go and do their verification exercise of information received at the registration center. So Gail Teixeira comes there and registers. Gail Teixeira is entitled to be living in England. Until we change the Constitution, that is the legal position in Guyana. So she comes on holiday in Guyana, and she goes to a registration center, and she registers because she's 18 years and over. She looks much younger. And she's a Guyanese citizen. But GCOM needs an address. Gail Teixeira is free to give an address in the area that she's likely to vote if she decides to come back to vote. When GCOM goes now, because GCOM is entitled under the law, and we have preserved that power, to go to that address to verify. But Gail Teixeira gone back to England. All GCOM is entitled to do is to verify the existence of that address. Not that she's resident there, because she doesn't have to be resident there. You understand? So when GCOM was going to do this and telling people they have to be resident, they have to be there, and if they're not there, they're not registering them, it's completely wrong. That is clarified in the law once and for all. Now, as I said, if it is that under the constitutional reform exercise, there is going to be change to that, well then the law will have to be re-amended. But until that change exists, we have to clarify the law and bring the law in conformity with the Constitution. That is our duty as lawmakers. So that's the third issue. The fourth issue has to do with the vexed question of removal of dead persons from the list. So let me go through this piece by piece so that everyone understands. The Registrar General of Births and Deaths, appointed under the Registration of Births and Deaths Act, shall, on request in writing of the Commissioner, Commissioner meaning the Commissioner of Registration, send to the Commissioner once every month a list of all persons 14 years and more, because it's 14 years and more that you can be on the list, whose deaths have been registered under the Registration of Births and Deaths Act in the preceding month. So it's a monthly cleansing exercise. Now, I have heard the argument that what about if the death is not registered? We can only deal with what is in the system. And I will deal with it just now to show you what other mechanism can be used. So we understand that clearly. Subject, then it goes on. Subject to this section, the registration of any person under this act whose name is on the list of dead persons sent by the Registrar General to the Commissioner under Section 8A shall be cancelled. Right? So once your death is registered, and then we check this list, and you are there, you are cancelled. And the law provides for that. Not only this law provides for it, but it's in the Constitution as well. The Commissioner shall prepare, that's it. The Commissioner, meaning the Commissioner of Registration, shall prepare a list from the Central Register for every division comprising of persons registered in the division that are on the list of dead persons sent by the Registrar General, and certify and send the list to the registration office of the division. This is now the implementation. The registration office of the division shall submit a list of names received from the Commissioner as a separate list to claims and objections under Section 15. So everyone now, all the political parties, and the whole country now, will see, I don't want to call somebody's name as a dead person, but that person died. And that person's name is now up to be removed. And the claims and objections allow you, members of the public, if you know of a person who may have died in your village or your community, and that person is not on the list, to now object. Or to claim, make a claim to have the process amended. Submit a list of names received from the Commissioner as a separate list and accompanied by scrutineers, visit the address of the persons in the registration record to verify any information on the death of the person from the person living at that address. So there's an additional requirement, an additional safety mechanism. You can go now, if you wish, with scrutineers from the political parties, and go and verify the information if you think that the person is not dead, or you have information that contradicts the report that you are getting from the Registrar of Deaths. Notwithstanding any law, the Commissioner may request more information from the Registrar General, including information of the person who reported the death and how the death took place. So if you want more information, the law allows you to get more information, to interrogate the information that you have received, if you wish to doubt the information, the authenticity or the accuracy of the information you're receiving. If the Commissioner, after consideration of information obtained under Section 3 and 4, is satisfied that the person is dead, the Commissioner shall direct the cancellation of the registration of the person who is dead from the central and divisional registers. So, my friends, this is now part of the law. So all this talk and criticism about the list having dead people, it should not have. And not only is a responsibility cast